Okay, be honest. Have you ever signed a contract without reading every single word? Yeah, most of us have. But what if one of those words, just one, could bring a multi-million-dollar international deal completely crashing down? Well, that is exactly what happened in this incredible legal story, where one single, seemingly innocent word became a ticking time bomb.
It sounds crazy, right? That just one word could have that much power? But as we're about to see, in the high-stakes world of corporate law, the line between a partnership that thrives and a lawsuit that destroys, well, it can be razor thin.
So our story kicks off back in the 1970s, and it starts with what looked like a perfect match between two industrial giants. On one side, you've got L. Schuler AG, a huge German tool manufacturer, and on the other, Wickman Machine Tool Sales. They had just landed this massive, exclusive deal to be Schuler's distributor for the entire United Kingdom. I mean, this was supposed to be a golden opportunity for everybody.
Now, on the surface, the deal couldn't have been more straightforward. Schuler makes the big industrial presses, and Wickman? Wickman has one job: sell them. The contract locked them together for 4.5 years, giving Wickman the exclusive rights to sell all of Schuler's products across the UK. It was really a recipe for a massive, super profitable partnership.
But you know how it goes. The devil is always in the details. And buried deep down in the fine print of this agreement was one very specific and very demanding clause. And this clause would become that ticking time bomb right at the very heart of their partnership.
And here it is, Clause 7b. It says it's a condition of the agreement that Wickman's sales reps visit the 6 biggest UK car manufacturers every single week. Just let that sink in for a second. 6 companies every week for 4.5 years. That adds up to over 1,400 individual visits. A monumental task, to say the least. And I want you to pay very close attention to that one word, condition. It's going to be important later.
So for the first couple of years, Wickman goes all in. They're making hundreds and hundreds of these visits. But trying to hit that perfect record, it was pretty much impossible. Out of those 1,400 plus required meetings, a few inevitably got missed. We're not talking about a major failure here, just a handful of slip-ups in what was otherwise a massive effort.
So how did Schuler react to these few missed visits? Well, they didn't just send a warning letter. They dropped an absolute bomb. They declared that Wickman had breached the contract and announced they were terminating the entire agreement. Just like that. Over a couple of missed visits, they were ready to burn the whole multi-million-dollar partnership to the ground.
Wickman, as you can imagine, was stunned. They refused to accept it, arguing this was a complete overreaction. So the dispute escalated. It climbed all the way up the British legal system until it landed in the highest court in the land at the time, the House of Lords. The stage was set for an epic legal showdown.
And the arguments were polar opposites. Schuler's lawyers were very blunt about it. They said, look, the contract uses the word condition. In legal terms, that's an ironclad rule. Any breach, no matter how tiny, gives us the right to walk away. It's black and white. But Wickman's lawyers, they were arguing for common sense. They said ending a massive commercial deal over something so minor is just completely unreasonable. It's absurd.
So let's pause here. Put yourself in the judge's seat for a second. What do? The contract seems crystal clear, but the result feels totally unfair, right? Do you follow the strict letter of the law, even if it leads to a ridiculous outcome? Or do you try to find the real spirit of the agreement?
Well, the judges in the House of Lords looked at the case, and they delivered a landmark verdict. They decided to look beyond that one single word and ask a much bigger, more important question. What did these two companies actually intend when they signed this deal in the first place?
And this is where it all comes together. See, the word condition kind of has a double life. In everyday language, when we say it's a condition, we just mean it's a part of the deal, a requirement. But in strict legal terms, it's a nuclear option. It means a term is so vital, so fundamental, that if you break it in any way, even just a tiny bit, the other side can blow up the entire contract. And that distinction, well, it was everything.
The judge's ruling really boiled down to this. They said if we interpret the word condition in its super strict legal sense, the result would be commercially senseless and totally unreasonable. They basically asked, could Wickman have possibly meant that missing just one single visit out of more than 1,400 would give Schuler the right to end the entire deal? And the court's answer was a firm no. That couldn't have been the true intent.
So Wickman won the case. The partnership was saved. But the impact of this decision went way beyond just this one deal. It created a powerful legal precedent. It confirmed that courts can, and absolutely will, look past the literal words on a page to find a commercially sensible meaning. It changed the game.
So what's the big lesson here? Well, first, calling something a condition in a contract is definitely powerful evidence, but it is not some unbreakable magic spell. Second, courts will always look at the bigger picture, the entire context of the deal. And most importantly, if following the literal word leads to a result that makes absolutely no business sense, they'll probably conclude that wasn't what the parties truly intended to begin with.
And this all leaves us with one final crucial question. This story isn't just about some business deal from the 70s. It's about every single agreement we encounter in our own lives. So the next time you look at a contract, maybe for a new job, an apartment, or even when you're just clicking I agree online, it's a powerful reminder to ask yourself, am I just reading the words, or do I actually understand the intent? Because as this case proves, that can make all the difference in the world.